Hi, and welcome back to another episode of Boardroom Conversations. Today I'm joined by Sinead. Would you like to introduce yourself?
Hi, Helen. Yes, my name's Sinead Kelly. I'm a senior associate in the employment team at Collier Bristow.
Thanks for joining us. Today we're going to be talking about directors' service agreements. I guess the initial question that actually it's worth asking is when you've got directors of a company, what sort of contract should you have in place for them?
Yeah, good question. So, all directors of a company are office holders. Some of the directors might also be employees, and others will be non-executive directors. So, not employees, but they will assist the business in more of an advisory capacity.
Mm.
So the first step, I guess, is to identify whether the director is going to be an executive or non-executive director, and then you can draft the appropriate contract.
Yeah. And I guess the difference for people who are listening is that a non-executive director isn't necessarily an employee of the company.
No, they are not employees. They don't have the same employee rights as an executive director. They, as I say, act in more of an advisory role. So
Mhm.
they might have certain field of expertise that they can advise the company on. And they also help to sort of hold executive directors to account to make sure they are performing their duties.
Yeah. Sounds like a pretty important role. And so there's differences between the kind of contracts that you would have with each of those. So do you mind talking a little bit about what each of those are?
Yeah, of course. So for an executive director, they would have a director service agreement in place. And that's essentially a contract of employment which sets out specific director duties that apply to the individual in their capacity as an office holder, as well as general employment terms. So, directors are the people appointed by shareholders to run the day to day management of the business. And it's really important for the business to have a document in place that provides clarity on the duties and obligations that are expected of the director. And also at the same time, it's helpful for the director to have a written contract in place because that agreement will set out their rights, including in relation to remuneration and
Mhm.
benefits.
Yeah. Quite rightly, you touched on accountability before, in that instance, sort of between executive and non-executive directors, but also it's worth mentioning that the shareholders of a company do have the right to inspect those agreements just as a way of holding the board accountable and making sure that they're not perhaps being a bit overly generous with their pay, as one example, or whatever it might be. So directors should be thinking about what's appropriate in any event, but they should also be aware that there is a mechanism for checking what's been agreed.
Yeah, absolutely. So you don't want any provisions in there that, might reflect badly on the individual director or could cause any sort of reputational discomfort for the company if there was a sort of particularly generous benefit provision or something.
Absolutely, and I think you mentioned that that applies to the service agreements for the executive directors. But what's the contract in place for a non-executive director, or the contract that should be in place, perhaps we should say?
As the non-executive director isn't an employee, they don't need a contract of employment, but it's still advisable for them to have some form of written agreement in place. And ordinarily, what we might see is what's called a letter of appointment, which is much shorter than a service agreement, as it doesn't need to cover all those general employment rights. But essentially, it sets out the key provisions of the engagement and, in particular, the director's duties.
Right. It's good that you mentioned that actually, because we have actually talked previously in another episode about the duties that directors are subject to, and those apply across the board to executive and non-executive directors, and are really important. So yeah, always should be forefront of them. And I guess you've mentioned a couple of times that there are sort of different terms that should be, or various terms that should be covered off in these agreements, whether it's a service agreement or a letter of appointment. What would you say from the company's perspective are some of the particularly important provisions that should be considered?
Yeah, well, firstly, just to mention that whenever companies are drafting, either a service agreement or a letter of appointment for a non-executive director, they need to make sure that the drafting's in line with the company's articles. So just worth keeping that in mind.
Love that.
But
I love that you mentioned that up front. We're always mentioning that to clients, and it's you'd be surprised how often there can be some quite significant inconsistencies and the difficulties that can get people into. So yeah, absolutely, that's got to be sort of right up there as one of the top considerations.
exactly. So it's definite starting point. And the main points that a company might want to pay particular attention to when drafting a service agreement would be whether the director's appointed for a fixed term or for an indefinite term, and in
Mhm.
either case, building in appropriate notice provisions.
That makes sense. From the company's perspective, you want to be sure of how long you've got a director in place for. It's helpful to have that certainty, but also sort of circling back to what you mentioned before, you don't want a situation where they've got a, let's say, a three-year fixed term under their service agreement, but the articles say that actually they have to resign and be reappointed every 2 years.
Yeah,
That's when things start to get
absolutely.
messy.
Absolutely. Following that point, it's just worth mentioning that it's not possible to agree to a notice period or guaranteed fixed term of more than 2 years without shareholder approval. So definitely the company would need to be quite careful about the drafting
Yeah,
of a provision like that.
a really good point, because actually it would be something that would be very easy to overlook if you weren't taking legal advice or hadn't given it thought. So yeah, no, really helpful. And I guess as well, it's quite important to consider more for non-executives who aren't going to be full-time employees, how much time they're required to give to a company. Do you find that something that tends to be negotiated?
Yeah, definitely. Especially if a company is paying quite a sizable fee, then I think it's quite important for the parties to have in mind the expectations of the time commitment that that non-executive director will spend with the business. Often, non-executive directors might be engaged by a number of companies, so
Mm.
they have quite a lot on their plate at any one time. And in the letter of appointment, you might be able to confirm, for example, that you'd want them to work for 2 to 3 days per month for your business.
Yeah.
And also, you might factor in that you'd want them to attend certain board meetings or an AGM or something like that. So there's more clarity on the exact commitment that's expected.
Mm. Yes, absolutely. Because often articles or a shareholders agreement where the directors may also be shareholders require that board meetings are held once a month, once a quarter, whatever's appropriate for that business. And you need to ensure that whoever you're bringing on board will have availability for that. Otherwise, you get awkward if you're missing half the board.
Absolutely.
And you kind of touched on this before, I think, but the idea of what actually, not just in terms of time commitment, but also what is expected of directors in terms of the duties or the responsibilities that they'll undertake. I think we've talked before about how it can be really helpful to address that in the contract. What kind of things might you expect to see in there?
Yeah, so definitely important to set out the director's duties in writing. As you will be very familiar with, Helen, there are very specific director duties set out in the Companies Act. They don't need to be copied out verbatim into the service agreement necessarily, but they should certainly be signposted along with any other duties that are expected of directors.
Yeah, I can see why that would be helpful, just to sort of bring it front and center to their minds that there are certain obligations on them. Are there any other terms that you see a pattern of being negotiated?
Definitely, from a business perspective, the main terms that they're interested in will be things like setting limits on the director's other interests. So, if they've got holdings in other companies, for example, they'd want to ensure confidentiality, and that's during the employment and after employment. If there's any intellectual property rights, they'd want to make sure there's adequate protection there. and crucially, including appropriate post-termination restrictions to ensure that the business is adequately protected when the relationship ends.
Yeah, it's always a bit awkward, isn't it, to have to talk about how things will end up front. People can be a bit hesitant because they don't want to be seen to suggest it won't end well, but actually it's part of a commercial discussion, and directors will normally be, well, certainly should be experienced enough to understand that you need to cover these things off. And you need to think about, actually, even if it ends really well, the company needs to have the confidence that they've got appropriate obligations in place to mean that a director can't just go running off to a competitor and say, oh, I've gained all this helpful information, time to share.
Yeah, absolutely. So, the main sort of provisions that you might include there would be things like a non-compete or non-solicitation of clients, customers, staff, non-poaching, potentially non-dealing. There's a whole range of clauses there. But the crucial thing for a business to be aware of is making sure that the post-termination restrictions only go as far as is necessary in order to protect the business, and they don't go too far, or they might have some difficulty with enforceability if it takes that route.
If it gets to that stage. Yeah, absolutely. I think it's really important. Actually, one point that we'll often make to clients is that this question of enforceability of restrictive covenants can be different in different capacities. So I know, for example, the employment tribunals tend to be quite strict in their interpretation of what's reasonable for an executive director. But where you've got, for example, directors who may also be shareholders, you can have a shareholders agreement, which, because it's viewed as a more of a commercial negotiation, often you can have slightly stricter restrictive covenants in there. Stricter restrictive covenants isn't great English, but we'll skate past that. And so you can give some thought to, well, what's reasonable in the context of an individual being a director, what's reasonable in the context of them being a shareholder. And those two don't actually necessarily need to be entirely the same. It's really worth giving some thought to that. I mean, we're getting slightly off topic here, but where a director is also a shareholder, there might be other restrictions that you can include within a shareholders agreement. As one example is good, bad, leave, which is actually going to be the next episode in this. But we've also talked a bit about other obligations along those lines in an earlier episode about shareholders agreements. So sorry, slight segue, but
Absolutely. I think it's a really important point that you raise. And in fact, when drafting service agreements, as you'll know, we often work closely with our corporate colleagues when looking at provisions in a service agreement that relate to termination of employment that could trigger a bad leaver provision. So it's really important, I think, to be aware of provisions that are in the shareholders agreement. And as you say, the post-termination restrictions might not be mirrored between the two documents. And it's important that the employment ones are drafted in a way that an employment tribunal or court might find reasonable in an employment context. But it's certainly worth being aware of what else is out there if there are other restrictions in a shareholders agreement.
Yeah, it's good to know what your options are, isn't it? And where you can go with these things. And actually, I feel like so far we've really focused on what those negotiating on behalf of the company need to be considering. But of course, the individual directors will also be fairly interested in making sure that these agreements work for them as well. So are there any sort of particular, if you're advising a director, are there any particular points you'd be looking to draw to their attention other than those that we've discussed?
Often when we act for individual directors, key provisions are generally focused around the package, the sort of remuneration and any benefits. So there might be some negotiation on things like, would they have private medical insurance or a company car included as well? They might also have a right to a bonus. And obviously a director is going to want as much certainty around the payment of any bonus as possible, whereas the company might try to draft it on a very sort of discretionary basis. So often that can be a real sort of negotiation point.
I guess as well, the question of notice period on both sides will be fairly important to consider.
Sometimes businesses think that it's necessary to have a long notice period for a director of, say, a year. But in fact, I think both parties need to think about what is actually going to be convenient and suitable. So from a business's perspective, they really only need to have a notice period that provides them with enough time to try and find a replacement, potentially do a handover and make sure the business is protected. And they wouldn't want to be in a position where they've got somebody new lined up but still have to pay out the departing director a huge sort of lump sum or sort of payment on garden leave of the balance of a notice period. Equally, for the individual director, it might seem beneficial to have a long notice period because that might, give them more time and more comfort in finding an alternative role. But equally, if they find a new role that wants them to start very quickly, they probably wouldn't want to be sort of sat on garden leave for potentially up to a year. So it's really worth having a good think about the length of the notice period and making sure it's appropriate in the circumstances.
That makes a lot of sense. It's a really fine balance, isn't it? And it's worth considering these things in the round. Again, not because you want to be assuming things will go wrong from the start, but just because, if you're negotiating a contract that's going to last a couple of years, you don't know what's going to happen during that time, and you want to find that middle ground between certainty but also having the flexibility if something does change.
Yeah, definitely.
One other point is just in relation to sort of directors and officers insurance.
Yeah, often directors are quite keen to push for that, certainly to have it included as a contractual right. And it is really important for directors because it protects them in the event that a claim's made directly against them as a result of a decision or action they've taken while carrying out their duties that are owed to the company. And they, obviously want to ensure that they do have that protection in place.
Yeah, again, putting myself in the shoes of the director, I can see why that might be something that I would want some comfort on.
Same.
That's been really helpful and hopefully given people who are listening some food for thought for when they're negotiating these types of agreements. Thank you so much for joining, Sinead.
Thank you for having me.
Thanks to everyone who's been listening. I hope you found it helpful. If you do have any questions coming out of this or any of the other episodes in this series, then do feel free to get in touch. You can find Sinead and my details on the Collier Bristow website, which is www.collierbristow.com. Thanks again for listening, and until next time.